We are on the record. This is Judge Warner speaking at Civil 2021-005416. Return on an order to show cause. Plaintiff's counsel announce.
Good morning, Your Honor. This is Jonathan Ebertshauser on behalf of Greenfield Lakes Owners Association.
Thank you. And Mr. Williams, are you appearing for the defendants?
I am, Your Honor. Good morning. We did enter a notice of appearance on Friday. I emailed a copy of it to your judicial assistant. And I am representing the defendants, John and Sarah Zifcak. Okay,
great. I guess I want to start off by asking whether the two of you had a conversation since the application was filed. Let me ask you, Mr. Williams, have you guys talked at all?
Mr. Eberhauser and I did speak on Friday. There's kind of two separate issues. There's the building the fence, and then secondarily, who should pay for the rebuilding of the fence. Those really seem to be the two emergent issues. We did send a proposal to plaintiff's counsel yesterday. He has indicated to me, and I won't speak for him, but that he has not had an opportunity to have the board consider that proposal yet.
I take it that getting the fence built is more emergent than deciding who should pay for it.
Yes and no. Without delving too much into the facts, Your Honor, there's an issue as to the contractor that the HOA that the association has selected to repair the perimeter wall. My clients feel as though they've been somewhat excluded from the process. There was an invitation early in the process to invite them to participate in the bid selection, and from their perspective, that really did not occur, and that the bid that has been selected from the contractor, there's a question as to whether that contractor is qualified and as to the cost ultimately to make the repairs. My clients feel that there's other contractors that may be more qualified that can do the work for less.
Okay, will you try to give me a visual on where exactly this wall is?
Sure. I mean, the front of my client's property is facing east to west, so the property itself faces westward. The front of the property eastward is the east side of the property faces the front. The west side of the property faces the back. The perimeter wall is the back wall of the property, and it basically butts up to a private street. So there's not a property directly behind my client's property. Currently, there is temporary fencing that is blocking the property. It's our position that the temporary fencing is secured, and that no one can simply just walk into the property unless they literally jump the fence like they could any other sort of masonry type walls construction. So at least currently, the back wall opens up to the street. There is a pool in my client's yard. I don't believe the pool has a fence around it. But then the temporary fencing that was put up by the association, in our mind, is properly securing the property. It's not a permanent fix, but it's certainly not one that requires us to jump everything today and start construction tomorrow.
All right. Mr. Ebertshauser, do you agree with some of that, all of that?
Some of it. I certainly agree that there are two issues here. The emergent issue is the reconstruction of the fence. The issue of reimbursement is something that we can address at any time. As identified, this problem spans 3 homes. The Zifcak's fencing was completely lost, and then each neighbor on each side of their property lost about half of their walls. All 3 of their properties have pools that are now unsecured by a masonry fence. And the association is concerned that the temporary fencing could be easily moved by minors or any interested party that wants to gain access to those pools. And the concern is that Mr. Zifcak and Mr. and Mrs. Zifcak's position here is subjecting themselves and their neighbors to significant liability as a result of a drowning. From a fairness perspective, that doesn't make sense. And from a reconstruction position, I suppose there's really no reason to delay this. The association is willing to front the costs of the reconstruction. The vendor that's been selected is licensed, bonded, and insured. They're actually very well known in the industry. They're members of both of our lobbyist organizations that kind of are involved in the community association industry. But this isn't a situation where the board has been kind of rash in decision making. There were 13 bids selected or solicited. Only 5 of those bids, of those contractors, even submitted. Most said not interested. And so from a timing perspective, this just isn't something that we can delay for further bidding to see if we can get another licensed and bonded insured contractor to take a look at this. We've got a licensed, bonded, insured contractor. To the extent that there's any problems, there's recourse. We can correct those problems. It seems to me that this issue is damage related, and that's a question that can be answered at a different time. We've already had engineers look at the property. They've come up with plans to do the work. Titan Restoration, the vendor that was selected by the association, is ready to do the work. They've already been on the property to start the work. The only reason the wall's not constructed is because the police were called.
And the other two homeowners don't have an issue with it?
We've raised no issues with Titan Restoration.
All right. So I would not grant TRO today, but I'm happy to set an evidentiary hearing quickly on this. What is your sense of timing, Mr. Ebertshauser, and what exactly am I going to hear at that? I don't mean, don't tell me what I'm going to hear. Who am I going to hear from? What kind of hearing are we talking about?
Timing, I suppose, the preliminary injunction request is limited to the right to reconstruct the wall. And so I suppose that comes to a question of, is Titan Restoration a qualified company to do the work? I don't think that the issue of financial reimbursement or the amount of their bid is really relevant to that question. And so I suppose we would have Titan Restoration present their qualifications.
And would I be deciding who's the best contractor, or would I be applying some sort of deferential standard to the board? And I guess that question turns on whether under the CC&Rs, the homeowner gets to pick the contractor or the board gets to pick the contractor.
It's a party wall, and so I don't think that we have certainly this is a situation where the parties need to work together to resolve the question. I suppose that depends on the defendant's position. If their position is the association is responsible for the cost of repairing the wall, then there's no reason we would delay at all. The association is entitled to pick the vendor in that scenario. If the court assigns to the association's belief that this is a party wall, then it's a joint decision between four individuals.
All right. So in terms of a hearing, how long, how far out?
I suppose we would need, with the construction the way it is, it's been difficult to get scheduling for the vendor. So from a witness perspective, we'd probably need at least a week or two for an evidentiary hearing.
All right. Mr. Williams, what do you think?
Your Honor, I honestly don't think we need a quick evidentiary hearing. I'm not trying to delay this, frankly. I think the proposal that we've set forth to the association's counsel and for the association's consideration is a legitimate consideration. The wall fell in early December of 2020, and the temporary fencing's been up all that time. So I don't know that we need to rush to get a hearing set for next week. I think we should allow the parties to try to work through this issue. If the association, I guess there's two different issues. If the association wants to take the position that it's a perimeter wall and they're responsible for the full construction, then I guess we could say, fine, you pick the contractor and you bear the complete cost of that. If they are expecting the Zifcaks to bear any responsibility for the cost of that, then they should have a role in the selection of the contractor. And they haven't had any role up to this point.
All right. I'm going to set an evidentiary hearing for April 30 at 1:30 for 2 hours. Any conflicts with that date?
Not from defense counsel, Your Honor. Just for clarification, is that going to be by Court Connect?
Yes.
Okay.
You said 1:30, Your Honor?
Correct.
That appears to work on my end.
Okay. So we'll set an evidentiary hearing on April 30 at 1:30 for 2 hours. I'm going to require the parties to electronically file all exhibits into exchange exhibits. Sorry, so the clerk is clear. 3 things. Electronically file exhibits is the first. The second is exchange exhibits. And the third is to file a witness and exhibit list. All that must be done by April 28 at 3 o'clock. When you file your witness and exhibit list, please email it to each other and to my staff so that I don't get any e-file delays. Look, my expectation is that you guys will work hard to work this out. And my experience in cases like this is that there's a pretty good chance you will. But in case you don't, I did need to set an evidentiary hearing because I've denied the request for TRO. excuse me, and I need the minute entry to reflect that I'm denying a request for a temporary restraining order and setting it for an evidentiary hearing on preliminary injunction. Before I ask you for any clarifications, I've moved awfully fast, and I think I might have a trainee clerk today, and I want to make sure she understands. Rhonda, do you understand everything I just ordered?
I do.
Okay, thank you. Anything we need to talk about beyond that, counsel?
Nothing from defense counsel. Thank you, Your Honor.
No, Your Honor, I think we're good.
Okay, good. Just let my staff know and file a notice if we need to vacate the hearing because you've resolved the case. Otherwise, we'll see you back here on April 30.
Thank you, Your Honor.
Thank you very much. We are in recess.